Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. Today we will discuss Section 148 of NI Act. NI Act means Negotiable Instruments Act. The said protocol basically indicates the power of appellant court to order payment pending appeal against conviction. So, we could say that by the bare perusal of Section 148 title, we may draw the five important conclusions. Basically, it is indication of the power of appellant court. The said section power cannot be exercised by the trial court. It is basically regarding the order to make payment of certain amount. The appeal must be pending and it must be against conviction. In case the concerned accused inter alia is of view that no appeal is to be preferred against conviction, then suo motu the power cannot be exercised. And apart from that, there must be requirement of a conviction. If there is no conviction, the power could not be exercised. Apart from that, we have to understand the fundamentals of section 148 of NI Act. It says that I am emphasizing on subclause number 1. Please note the same in your notebook. It says that notwithstanding anything contained in CRPC. Now we are having BNSS. So, from the inception, it is clear that the approach is negative. Because even though a negative point is contained in CRPC, despite of that, the appellant court has to exercise the power. In that scenario, in an appeal by a drawer against the conviction under section 138, the appellant court may order the appellant to deposit such sum which shall be minimum of 20% of fine or compensation awarded by concerned trial court. So by the bare perusal of clause number 1, it is quite clear that there is a requirement of an appeal which should be against conviction. Conviction must be under section 138. In that scenario, the appellant court may order. It is basically the discretionary power. But what amount is to be deposited is minimum of 20% of fine or compensation awarded by trial court. To be noted that on that point, we are having a proper defense strategy. We are having the important judgment of Honorable Rajasthan High Court titled as Jinesh Soni versus State of Rajasthan. In that case, the court is of view that if the concerned accused is having the financial crisis, in that scenario, the amount of fine can be replaced with amount of check. In that case, the concerned court of appeal inter alia awarded 20% of fine amount, but inter alia it is replaced with check amount. Apart from that, we are having the important judgment of Honorable Punjab and Haryana High Court. In said case, only 5% of fine amount was directed to be deposited, but the amount was not given to complainant. It was directed to be deposited at registry to parry any prejudice to interest of concerned accused. Apart from that, we are having judgments of Honorable Supreme Court wherein it is specified that if the accused is having a strong case in his favor, but unfortunately it was not considered by trial court, in that scenario, the concerned court of appeal may decline the order and could pass order in favor of accused. So on that point, we are having three important judgments which I awarded or narrated to you. Please note down the same and apply the same in the practical way whenever you are going to argue concerning the protocol of section 148 of NI Act. Now the important question arises, how these powers are exercised by the concerned court of appeal, either suo motu or on an application by the complainant. The answer is the powers are exercised suo motu. To be noted that when you are convicted as per section 138, you are having an option to file an appeal, but appeal is to be filed within a period of 30 days. With appeal, we usually file an application called SOS, named as suspension of sentence. When the application is accepted, in that scenario, you are allowed to be on bail during the pendency of appeal. And while making such order, the court may direct you to deposit the amount as per protocol of section 148 of NI Act. So, we could say that the amount payable under section 148 subclause 1 shall be in addition to interim compensation paid by the accused as per section 143A. Although we are having the protocol of set-off or counterclaim, but despite of that, the amount could not be adjusted. But if you are having the financial crisis, you are contesting the case concerning section 148 of NI Act, you may plead this point and the same can be utilized as defense strategy number 2. To be noted that there is a specific time period to comply with the order of court inter alia pronounced as per subsection 1. Subsection 2 says that the amount referred to in subsection 1 shall be deposited within a period of 60 days from date of order. In a case it is not deposited, a further time of 30 days could be given. But for this, you have to show the sufficient cause, otherwise the order could not be extended. Now the important question arises. What will be the negative implication if the amount is not deposited? The SOS means suspension of sentence order would be vacated, your bail bonds would be forfeited, and ultimately you have to surrender. In that scenario, you might be imprisoned. Sometimes there is a scenario that the amount is not deposited, but despite of that, a compromise outside the court between the accused and complainant occurred. In that scenario, exemption could be given, which is permissible as per section 148 subclause 2 of NI Act, read with section 147 of NI Act. Now the important question arises, in case you are succeeded, how to get back the money? To be noted that the appellant court may release the amount deposited by you to complainant during the pendency of appeal. So basically it is a discretionary power, not mandatory for the court. The usual trend is that the amount is to be deposited with registry, but it is also a trend to deposit the amount to complainant. But the key point is that we have to protect our interest also, and that's why we could insist the concerned court that there is a proviso in which it is specified that in case the appellant is acquitted, the court shall direct the concerned complainant to repay the amount. 60 days time is given, and this time can be extended by 30 days if sufficient cause is shown, but the protocol is theoretical in nature, not practical. In case money is given, it is not refunded, only an order regarding levy of warrant could be passed. In that scenario, infinite time would be taken to recover the amount. So to parry all such scenarios, it is requested to deposit the amount with the registry. Such prayer is to be made, or the concerned complainant is to be compelled to execute indemnity bond with surety so that the chances to refund could be enhanced. And apart from that, the concerned complainant has to pay the bank interest, which is to be considered as per the protocol. As per protocol, the interest means the interest at the bank rate published by the Reserve Bank of India prevalent at the beginning of relevant financial year. For example, order is made in the year of 2021. The financial year for that year would be 2021-22. In that scenario, the bank interest prevalent for that financial year would be taken into consideration. So basically, I inter alia convey all of you the fundamentals to contest section 148 NI Act contentions so that you could efficiently contest the same and could protect your rights from being prejudiced. I think I inter alia convey you all the points for your better understanding and updating of your information. See you in the next video. Till then, Jai Hind, Jai Bharat.